welcome to Thursday morning coffee break with DCE Law. So I'm so happy that you're joining us today. Today we're actually going to be talking about the process of divorce in the state of Florida. So I'm Deborah Sermonaro Eldridge, and I am the attorney and owner of DCE Law. I'm a licensed attorney here in the state of Florida, so any information or legal advice that I give at the state level is based on the laws of the state of Florida. I cannot give legal advice outside of the state of Florida on any other state's laws. Now, that's not to say that the information I provide to you may not be similar in your state if you're joining us from outside of the state of Florida. But it's always good to go ahead and you need to check with an attorney local to you to make sure that, in fact, you're getting the most relevant and up-to-date information on that particular area of law. So with that said, I want to go ahead and get started. I had said last week I was going to go through the process this week of divorce and what is the value in knowing this information. If in fact you are thinking about getting a divorce, it's good to know the process, and the information that I provide to you is information that I would provide to a client who is coming to me and for an initial consultation and wants this information. Last week I talked with everybody about the difference in the elements of divorce, whether it was finance, your children, custody, retirement, assets, liabilities, and all of those topics. So with that in mind, I'm going to go ahead and start talking about the actual process. So here in the state of Florida, we have contested dissolutions of marriage. We have uncontested dissolutions of marriage. Under the uncontested realm, we also have something called a simplified dissolution of marriage. That applies to couples who do not have any children. So you cannot go that route if you don't have children. If you do have children, you can't go that route. If you still want to enter into an agreement with your spouse for the divorce, you can in fact do that. It's just that it's called an uncontested dissolution of marriage instead of a simplified dissolution of marriage. Then on the other spectrum, we have the contested dissolution of marriage, and that is where we're going through the entire process because the parties cannot agree. Now, you have to go through something called mediation, but we'll talk about that in a minute. This is just basically the 411, the basics of the process. So once you decide that you do want to go ahead and get a divorce, let's talk first about the contested realm. If the two of you cannot agree on anything, what's going to happen is that you are actually going to file a petition for dissolution of marriage in the county in which the two of you last resided as husband and wife. That's very important because what I'm finding with a lot of these organizations that are do-it-yourself, they are actually filing your documents in a county where you never were married. They're doing it because it's the cheapest county to file in for divorce. The problem is if you have issues with the divorce, now you have to go to that county, which may be 2-3 hours away from you. That makes no sense. Let's do it simple. Let's do it right. Anyway, so a contested dissolution of marriage is filed. And once you file that contested dissolution of marriage, you have a certain amount of time to serve your spouse. Sometimes what happens is we have to locate the spouse, and that's okay. If we have to locate the spouse, we will do that, or sometimes we have to actually hire an investigator. Nonetheless, you have a certain amount of time in which to file your petition in which to serve your spouse once you have filed. Once they are actually served with the petition for dissolution of marriage and the summons, then they have 20 days to respond. They can respond in different ways, but they have 20 days to file an answer and counter petition or an answer alone. And they can actually even try to file a motion to dismiss. There are certain grounds on which they'd be able to do that, but it really depends. So once they file their answer and counter petition, now the case is open and we go through what's called the discovery process. You have something called mandatory disclosure that has to be provided to the other side. And what that is all of your financial records, all of your information regarding assets and liabilities, all of that information has to be disclosed to the other side within a certain period of time as well. If you don't provide that information within that period of time, then we have a problem, because then what happens is you can get in trouble with the court because the other side can file a motion to compel, and so on and so forth. So nonetheless, you have this time period. You have to get your disclosure over to the opposing party and their counsel if they have an attorney. Otherwise, you have to give it directly to them. Fine. We go ahead, we get through that process. Then we file what's called discovery. Mandatory disclosure is part of discovery, but we also have interrogatories, requests to produce. So we go through this, what we call discovery process. It may involve depositions, it may involve subpoenaing records, but we get through that process. And then oftentimes we may have a case management conference if it's dragging on, because the court then wants to know what's going on and why it's taking so long. After we get through that discovery process, at some point we're going to have mediation. It could be during the discovery process or at the end of the discovery process, but you're going to have mediation. If you have children involved and if you need temporary support, then we go through another process earlier in the proceedings, which is called temporary relief. And what we do is we file a motion for temporary relief, and we go through a temporary relief mediation. Now, the good news about that is sometimes you can resolve all of the issues at the temporary relief mediation. But the point of the temporary relief is to get you from where you are in the beginning of the process to the end of the process, whether it's trial, whether it's a final settlement, whatever it is, we have to get you through that. And if you've been relying on the other party for your primary support for that period of time, for your entire marriage or whatever period of time, and you have children, you're entitled to that relief so that you can continue to support your children and yourself. So there are all these little nuances and processes, but the point is to get you to the end, and the end is your final judgment. Sometimes we can go ahead and we can settle. Oftentimes we do settle cases. Most of our cases will settle prior to trial. But that doesn't mean that some of them aren't going to go to trial, because some of them are going to go to trial. If you can't settle at the full mediation, in other words, when you're looking at the permanent side of the mediation, then we do have to go through. Oh, my battery is running low. I did not realize that. Give me just a second. Been a busy week. Let's get this down here. Okay. Sorry about that. So if in fact we don't get it settled at the mediation, then what's going to happen is we're going to go ahead and we're going to then go through the process of a trial. And that's where it can get costly, especially if you have to have experts come in and testify. And that's another element of the process. So the whole point with all of this is that you want to minimize your expense and minimize your exposure as much as possible. In doing that, it's really important to pay attention to what your attorney is telling you, and to make sure that when your attorney tells you, there's certain information that you have to give them, that there's certain information that she or he needs to know, that you please get them that information. If you listen to your attorney and you work with your attorney is going to be able to help you. If you don't listen to your attorney, or if you do things that your attorney tells you specifically don't do that, and you go and you do that, you can end up hurting your case and your position. So it's very important. Once you get to the trial, then the judge is going to make a final decision. If the two of you cannot resolve your issues, whatever those issues are, the judge is going to get you to the final next step, which is the dissolution of marriage, and make that decision for you on the assets, liabilities, finances, custody, child support, and so on. So you want to go ahead, and if you're not willing to agree, you are putting your decision in the court's hands, and the court has to make that decision. So once that decision is made, then a final judgment is rendered of dissolution of marriage. And then it is filed, and then you have your divorce. Until that final judgment is rendered, you do not have a divorce. Now, after the final judgment is rendered, we'll talk about that on a different day, but I do want to say that you have 30 days in which you cannot get married or do anything. And the reason you cannot do anything in that 30-day period is because once a final judgment is entered, each party has 30 days in which to appeal the case. If they don't appeal that case in 30 days, you're good to go. But you can't get married to another person within that 30-day time frame in Florida. So I'm going to go ahead, I'm going to end this video, and I'm going to start another one on the uncontested process, so we can go ahead and we can delve into that. Hold on, and we're going to get to the next video.